Losing someone you love is just devastating, an emotional earthquake, really. And then, while you're still reeling, the mail starts coming.
Mm-hmm. Bills, statements.
Final notices, all addressed to the person who just passed away, demanding payment. This is immediate clash, grief and suddenly financial stress.
Yeah, it forces surviving family members right into this really confusing question, am I now responsible for what they owed?
It's a huge anxiety. And it feels like it gets worse when creditors keep sending demands. Maybe out of confusion, maybe not.
Right. And the immediate thought for so many people, spouses, kids, is that, well, this debt is now mine. It's been inherited.
That exact fear, inheriting a mountain of debt, is what we're tackling today. We're using insights from Peter Francis Geraci of Geraci Law, which offer really clear guidance here.
Yes, the aim is to clarify who is actually liable and give you, the listener, some essential steps to protect yourself while you're mourning.
So let's start with the big one. Is a surviving family member automatically on the hook for the deceased debts?
And the straight answer, legally speaking, is generally no. It's a relief for many, but debt doesn't just pass down the bloodline like, eye color.
Okay, let's unpack that because it really goes against what a lot of people assume. You see that pile of bills, you panic. Why doesn't it automatically transfer?
Well, the law is quite specific. You aren't legally responsible for someone else's debt unless you agreed to be. Usually that means one of two things.
Okay.
First, you signed something. A contract, a loan agreement, something in writing saying you'd repay it. Or second, and we'll get into this, you live somewhere with specific state laws about marital debt.
Right, the community property states.
Exactly. But without those exceptions, the debt belongs solely to the person who passed away.
Now, when families see this financial problem looming, a common reaction is to think about bankruptcy. I bet people ask all the time, should I file bankruptcy for my late husband to clear his debts?
Oh, absolutely. And that's probably the biggest misconception we need to clear up right away. You actually cannot file for bankruptcy for someone who has died.
You can. Why not?
Bankruptcy is designed to discharge your personal debts, the debts of a living person, to give them a fresh start. Death fundamentally changes the whole legal picture.
So once someone passes, the debt isn't handled through bankruptcy court. Where does it go? What happens to it?
It completely shifts. It stops being a claim against a person and becomes a claim against their estate.
The estate. Let's define that.
Right. The estate is basically everything the deceased owned: their house, bank accounts, investments, car, you name it. It's like a separate legal container for their assets.
And the place that handles this container isn't bankruptcy court. It's
probate court, or more broadly, the process of settling the estate. That's the arena now.
okay, probate. Let's dig into that a bit. What does that process actually involve?
So think of the estate as that pot of assets we mentioned. If there are enough assets in the pot, it typically has to go through probate. It's a court-supervised process, validating the will, identifying assets, paying debts, and then distributing whatever's left. An executor or administrator gets appointed. They're like the financial traffic cop for the estate.
The traffic cop, I like that. What's their main job?
Their duty is to manage that pot, gather everything up, look at all the claims from creditors, and pay the legitimate debts using the estate's assets. Only after that's done does anything remaining go to the heirs.
And the key point for creditors.
They have to file claims against the estate. They can't just demand payment from relatives who aren't liable.
So if I'm, say, the daughter, but my brother is the executor handling the estate.
Your responsibility is likely minimal regarding those debts. Your main job might just be to forward any bills you receive to your brother, the executor. You don't personally owe them. Your own assets are safe.
Okay, that covers situations with assets. But what if the person who died didn't have much? No house, maybe very little savings, just personal belongings.
That's actually a much simpler situation for the family, often a relief. If there are essentially no assets, there's no real estate for creditors to collect from.
So the debt just disappears.
Pretty much. Creditors usually just write it off. They can't sue someone who's deceased, and they can't successfully sue a relative who never signed for the debt. So things like credit card bills or medical bills often just die with the person who owed them.
That must be a huge weight off many families' shoulders. But we need to talk about the exceptions, because there are times when liability definitely transfers. Let's start with the most common one, co-signing.
Yes, this is the big one, the main undeniable exception. If you and the person who passed away both signed for a debt, a joint credit card, a co-signed car loan, a mortgage together, You remain 100% responsible.
The lender sees two names on the contract, and they don't really care that one person is gone.
Exactly. They only care who promised in writing to pay it back. If you're the cosigner, that obligation is now fully yours. They can pursue your assets for repayment.
What if someone isn't sure if they co-signed?
Good question. You need to check the original loan documents if you have them. Or check your own credit report. Cosigned debts should show up there.
Okay, that's a clear-cut, if painful, exception. But there's another big one that depends on where you live, and it catches a lot of people by surprise. Community property laws.
Right. This is where things get a bit more complex, legally speaking, and potentially riskier for a surviving spouse who isn't aware.
How so?
In most states, think Illinois, Indiana, Florida, New York, the majority debts are generally considered individual. If your spouse takes out a loan in their name only, it's their debt. Community property law flips that script.
Flips it how?
In community property states, the basic idea is that most assets, and importantly, most debts acquired during the marriage, are considered jointly owned or owed. It doesn't always matter whose name is actually on the paperwork. The debt belongs to the marital community.
So let's take an example. A wife takes out a credit card, only her name is on it. They live in one of these states, she passes away. Is the husband now liable?
Potentially, yes. That's the critical difference our source material from Geraci law highlights. If, say, Mrs. Jones in Wisconsin, which follows community property ideas for marital debt, ran up a credit card bill just in her name while married, Mr. Jones could still be held liable for it after her death, even if he never signed a thing.
Wow. Okay, we absolutely need to list those states. This is crucial information.
Definitely. The 8 main community property states are Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, and Washington. And, importantly, Wisconsin also applies similar principles to marital debt.
So 9 states total where this is a major factor.
Right. If you live in one of those 9 places, you need to be extremely cautious and probably get legal advice right away if your spouse passes. That general rule of debt dies with the debtor gets much trickier there.
That really changes the key question from, did I sign it, to where did we live when the debt was incurred?
Precisely. Outside those 9 states, it's usually about individual obligation. Inside them, the marriage itself creates a kind of financial partnership for assets and debts.
Okay, one quick side note before we get to practical advice. What about verbal promises? Like telling a hospital, don't worry, I'll handle his bill when someone's really sick.
Thankfully, those casual verbal promises are rarely legally binding for debts. It's very hard for a creditor to enforce something said under duress like that.
Where's the real danger then?
The danger is signing something specific, like a financial responsibility form at the hospital admission desk or a guarantor agreement. Sometimes you sign these things when you're distracted and worried. If you signed a paper saying you personally guarantee payment, that's binding, not usually a verbal assurance.
Got it. Okay, we know the exceptions, we know the general rule, but creditors might still call or send letters. How should a grieving family member handle those communications?
You need a clear plan. Be proactive, be firm, but stay polite. First step, gather all the bills and statements you can find. Get organized. Then, when you talk to a creditor, 3 key steps. 1, clearly state the person has passed away. 2, offer to send, or just send, a copy of the death certificate as proof. 3, and this is crucial, state very clearly, maybe even follow up in writing, that you are not legally responsible for this debt, assuming you aren't.
And the absolute don't. The biggest mistake someone could make.
Never, ever agree to make a payment on a debt you don't legally owe, not even a small token payment out of guilt or pressure.
Why is that so important?
Because doing that, making even one payment, could potentially be seen as acknowledging or assuming the debt. It could accidentally create liability where none existed before. You don't want to unintentionally revive a debt that legally should have died. Protect yourself financially.
Let's use that car loan example from Geraci law again. Mr. Jones's wife, Mrs. Jones, had a car loan solely in her name. She passes. The lender calls Mr. Jones.
Right. Mr. Jones, assuming he never co-signed, his response should be polite but firm. Something like, I'm sorry to inform you Mrs. Jones has passed away. I am not on that loan, so I have no legal responsibility for it. You are welcome to make arrangements to retrieve the car.
So the lender gets the collateral of the car back.
Exactly. They can take the car back because it secured the loan, but they cannot force Mr. Jones to pay any remaining balance out of his own pocket or from his own assets. That's the protection the law gives the non-liable survivor.
That distinction between secured and unsecured debt is key then.
Absolutely. Secured debts like mortgages or car loans, the creditor can usually take the collateral if the estate can't pay. Unsecured debts like credit cards or medical bills often just evaporate if there's no money in the estate. Either way, if you didn't sign or aren't in a community, property, state, marriage situation, your personal finances should be shielded.
Okay, let's boil this down. What are the 4 key takeaways for anyone listening who's facing this?
1. Gather all the financial paperwork, bills, statements, everything. Get organized. 2. If there are significant assets involved a house, savings, contact a probate attorney to guide you through settling the estate properly.
3.
Be firm with creditors. Crucially, do not make payments on debts that aren't legally yours. Don't accidentally take them on.
And 4.
4. If you're a surviving spouse, double-check your situation. Consult a lawyer before assuming any debt is yours, especially if you live in Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, or Wisconsin.
So the fundamental message is, the law generally protects the surviving family members. Grieve first. Don't let financial panic take over immediately. Understand your rights.
That's the core idea. The burden doesn't automatically shift unless you co-signed or those community property rules apply. Focus on settling the estate correctly if needed and protect your own financial well-being.
Most unsecured debts really do die with the debtor.
They often do. You don't need to rush to file bankruptcy for the deceased. That's not how it works. You need to understand the estate and your own agreements.
Okay, that brings us to a final thought for you, the listener, to mull over. We know creditors often continue collection efforts even after being notified of a death, sometimes just due to automated systems.
It happens a lot.
So the question is, how long should the law permit that kind of contact with a grieving, non-liable family member before it crosses a line? When does persistent collection activity become harassment in this specific, sensitive context? Something to think about.